Hi, I'm Emma Cunliffe. I'm the Secretariat for Blue Shield, and I'm going to just talk to you a little bit about new standards for cultural property protection inventories in armed conflict. So I work for the Blue Shield, which is an NGO established in 1996, named after the emblem in the 1954 Hague Convention for the protection of cultural property in the event of armed conflict, to identify protected cultural property. And in the 1999 Second Protocol, it was named as an advisory body to the UNESCO Intergovernmental Committee for Cultural Property Protection in Armed Conflict. Today, the Blue Shield mission has expanded beyond that. It's committed to the protection of the world's cultural property and is concerned with the protection of cultural and natural heritage, tangible and intangible, in the event of armed conflict, natural or human-made disaster. We're no longer the International Committee of the Blue Shield because we have national committees around the world. And so we comprise the International Board and its Secretariat and these national committees. And we do a lot of military training around the world, which you can see in this slide. And it's based on this military training with enabling armed forces who want to act in good faith and to follow international law that I'm talking to you here today. So Article 2 of the 1954 Hague Convention indicates the protection of cultural property comprises two spheres, safeguarding and respect, and it's safeguarding that enables the respect for cultural property. And whilst most people will focus on respect, that is the measures that enable, for example, targeting decisions, in fact, armed forces are also required to cooperate with civilian authorities responsible for safeguarding. Cumulatively, though, whether a state has complied with its obligations in relation to cultural property in conflict is assessed by the laws of armed conflict, which people don't really talk about very much. So an armed force operating in good faith, first of all, must distinguish between civilian property and a legitimate military target. Once they've made that distinction, then they must ask, is the attack still necessary, particularly given this is cultural property? And if it is, and there is no other way to obtain the same advantage, then what would a proportional attack be? How is the damage that is going to be inflicted on the cultural property proportional to the advantage to be gained, and can it be reduced in any way? So I have a couple of examples of what good practice looks like. So for example, in Operation Unified Protector in 2011, NATO identified 6 radar vehicles that needed to be destroyed, but we'd given them a no-strike list of cultural property, and by we I mean the international community. And as a result, when they were looking at targeting these radar stations, the vehicles were flagged as being next to cultural property. So whilst NATO were intending to destroy the cultural property in one blast, actually they reviewed their weaponeering options. They still needed to make the strike, but they realized that they could use more expensive weapons. They made 6 strikes with precision-guided munitions. It's more expensive and it's riskier, but it protects the cultural property. And if you have the resources and the information, this is the kind of choice you can make. And as you can see, the radar stations were destroyed and the fort was protected, or fortified farm. Similarly, these are the 8th century walls around Raqqa, which is a tentative World Heritage Site, but also where the ISIS Caliphate made its headquarters, in the centre of the Caliphate. And when the fighting to retake Raqqa was very heavy, they were unable to get through the main roads into Raqqa because they're quite narrow through these big walls. ISIS had mined the area, and so they chose to destroy 2 25-metre sections of the walls to preserve the rest. It was a very targeted, very strategic decision that preserved the majority of the cultural property and saved lives, but only a small amount was destroyed as a result. And this is what good faith decisions look like. And the way that we can enable this as heritage professionals is via inventories. Now, the Hague Convention gives a big definition of what goes into such inventories. Cultural property that is movable or immovable property of great importance to the cultural heritage of every people. And then it gives a big list of examples. And the idea is that it is up to states to determine what such cultural property of great importance might be. And they have to do that by naming a competent authority who has the authority to make that decision. And that person should then operate to collect together representative cultural property from all the peoples, communities that make up that nation. And this needs to be done collaboratively, as I'm going to show. Because, for example, what often happens is that the competent authority is the Ministry of Culture, and they only include the buildings that they have cultural remit for managing in peacetime. So to use a UK example, Durham Cathedral, in here's a picture, is a World Heritage Site and a listed cathedral. It's one of the most important buildings in the UK. On the other hand, local parish churches, the state has no involvement in religious structures, so they have no listing unless they have a certain level of religious significance, despite, of course, being highly significant to the local communities. In fact, we have about 50,000 churches in the UK, and only the most historically significant are listed for protection under the Hague Convention. Similarly, libraries are very rarely managed by Ministries of Culture and often excluded from inventories, despite the fact that we know from, for example, Sarajevo or this picture here of Mosul, that libraries are frequently targeted and need the same protection as other cultural property. Private art collections also often excluded, despite the fact that a huge number of private artworks are in huge number of famous artworks are in private collections. But because the state has no control over them, they don't list them in their inventories. And the other one is an age-based criteria. So, for example, the Twin Towers are obviously very significant, and the memorial to them is of great significance for a huge number of people, but would probably fail an age-based threshold. In the UK, for example, the Angel of the North is a very local symbol that represents my region, but it was denied listing recently because it's too recent. We also need to be very careful how we present the information to armed forces. We often give a centre point. So this is the centre of the World Heritage Site of Aleppo in the wider city of Aleppo. But in terms of making any kind of strategic decision, that is no help at all. In fact, the ancient city of Aleppo covers that area, a very small amount of Aleppo itself. And even within that, for example, if a site were to be placed under enhanced protection, the requirements are only that we give the boundary of the area. But if an armed force were to operate in that area, one who did not want to act in good faith, then an armed force acting in good faith lacks the level of information they need to operate effectively and would probably have to breach their obligations due to lack of information. In fact, only 540 or maybe 550 of the buildings within Aleppo are those contributing to the outstanding universal value. And this level of detail is absolutely essential. Lastly, we find that natural heritage is frequently excluded as well, despite its inclusion in the World Heritage Convention. So, for example, you can see here Dorset and East Devon World Heritage Site in the UK, which is not included in the UK's Hague listings, but which is a natural World Heritage Site, and the World Heritage Convention Article 6.3 states that high contracting parties, which is most of the world, should protect their cultural heritage in peace and in conflict, and that of other states. These are still protected areas. So in fact, what we need is to take a representative view of cultural heritage protection and not just make an inventory against the criteria in the Hague Guidelines, but against everything we want to be protected, recognizing that it needs to pull in information from the World Heritage Convention, from, for example, religious buildings protected under the 1907 Hague Regulations and under the Geneva Conventions, and that protected in the Hague Convention as well. And we need this comprehensive understanding of what it is we're trying to protect and why, in order to maximize the chances of things being protected in an armed conflict if a state wants to obey the rules of armed conflict. And that doesn't only go for foreign states, but also for our own armed forces. What information are we giving them when they operate abroad? They are obliged to protect cultural property operating abroad, and we need them to have the information to be able to do so. But of course, cultural heritage continues to proliferate. There's an awful lot of it, which is why the Hague Convention has a tiered system to prioritise it. Because in an armed conflict, resources aren't infinite, and there is a huge amount of decision-making to be done very quickly under pressure. And that's why the convention starts with cultural property of great importance. So if it's simply important, or even just, crop marks or those locally registered cultural sites, it doesn't rank for general protection under the convention. Once it is considered to be of great importance, then it requires a battalion-level commander to approve an attack upon it. But if it's very great importance, it may be eligible for special protection. Special protection sites may never be used unless a divisional commander gives the authorization to use the site, and only then, once it has been taken into use, may it be attacked. Similarly, sites of the greatest importance to humanity may be eligible for enhanced protection. Sites under enhanced protection may never be taken into use. If the opponent does take them into use, only then may they be attacked, and it still requires a force at the highest operational level of command, the force commander himself, to authorize the strike in order to end the threat that is occurring at the site under enhanced protection. And yet, to date, only less than 40 sites have been registered for special and enhanced protection, and both are very, very valuable. For example, about 130 states recognise special protection legally, whereas only 82 recognise enhanced protection. So there's a need for both of those sites, both of those to be registered, and for that level of prioritisation to be implemented. And then that information in turn needs to be in the inventory. But it's not just the what and the where and the legal status. It's about the type of military mission. Is it operational? Are they, for example, preventing looting? Is it about disaster response, or is it about targeting? And what sort of information do they need about the site? The picture below is an archaeological tell, so it might be looted, but it also has standing architectural remains. But in addition, it also has a modern cemetery. So an armed force who may end up operating on that site needs to be aware that there is a significance to the local community beyond the archaeological and the sensitivities of human remains. Similarly, what else is the site vulnerable to? Will it collapse under, a plane flying by, or is it vulnerable to looting? How big is the site? Does it have any security measures? If an armed force needs to prioritise where its protection may end up going, what information do they have to make those decisions? Given there may be hundreds of thousands of sites at risk, they can't protect them all, if they protect any. And that, again, depends on resources and having the ability to make those assessments. Perhaps it's disaster relief. What sites may need, for example, evacuation of their collections or the provision of a generator. And again, we need to be able to supply them with these information because there are multiple different branches who may operate in different times and phases of a military operation. It's not just about targeting. So in this very brief overview, I hope I've demonstrated the need to go beyond the what and the where in a cultural property inventory, and the need for comprehensive representative information collected together by partnerships between Ministries of Culture, Ministries of Education, and Ministries of Defence to identify the information that they need, and done representationally with the local communities. But in fact, the key question, if we accept the need to make the inventory, has never been, should we make one? Because the answer is yes. The key question to where international attention needs to be devoted now is who do we share it with and how? How can we keep that information safe and secure? And how can we determine that it is used in good faith? And these are the questions to which I urge the international community to turn its attention to now. Thank you very much.